Good morning and welcome back to the channel, and today we are talking about restrictive covenants and whether you can legally build an annex in your back garden. With rising house prices and families living together for longer, we're seeing more homeowners explore garden rooms, annexes, and self-contained spaces for relatives. The legal side of this can really catch people out. You might assume that if you get planning permission, you're in the clear. Planning is important, but it's only part of the picture. Restrictive covenants are private legal obligations written into property deeds, often many decades ago, that limit what you can do with your land. They can restrict building additional structures, using the property in certain ways, or even changing its appearance. They're not enforced by the council, but by whoever has the benefit of the covenant, which could be a neighbour, a developer, or a management company. We recently advised a couple who wanted to build a small annex at the end of their garden for an elderly parent. They had spoken to the local authority and were confident planning permission would be granted. The problem emerged when their solicitor reviewed the title and found a covenant from the 1930s, stating that no additional dwellings were to be erected on the plot. The couple were understandably frustrated. They had already spent money on drawings and surveys, and felt blindsided by a rule that felt outdated. Unfortunately, old covenants can still bite. Restrictive covenants are often misunderstood. Some are clear, others are vague, and many people only discover them when they're about to build, extend, or sell. In some cases, the person who can enforce the covenant no longer exists, which can make enforcement unlikely. In others, there may be a very active neighbor or developer who is keen to preserve the original layout of an estate. We've seen situations where neighbors objected to annexes because they believed it changed the character of the area, even though planning permission had been granted. So, what can you do if a restrictive covenant stands in your way? Well, one option is to approach the person with the benefit of the covenant and ask for consent. Sometimes this is given, and occasionally it might be in return for a fee. Another option is to apply to the upper tribunal to have the covenant modified or discharged, particularly if it is obsolete or unreasonably restricts the use of the land. This is a legal process, and honestly, it is not quick or guaranteed. But in the right case, it can unlock development that would otherwise be blocked. There is also a risk in simply pressing on and hoping for the best. We have seen homeowners build first and ask questions later, only to receive a solicitor's letter demanding that the structure be removed. That is an expensive and stressful position to be in, especially when the annex was built with good intentions for family use. At Blackstone Solicitors, we always advise checking the title to your property before committing to plans or builders. It can save you time, money, and heartache. Restrictive covenants are not there to spoil your plans, but they are part of the legal landscape of property ownership in England, and they need to be taken seriously. If you are considering building an annex or any other structure in your garden and you are not sure where you stand, getting early legal advice can help you move forward with confidence. If you found this video helpful, give it a like, subscribe for more practical property law insights, and feel free to get in touch with our team for tailored advice.